Okay, so I did this yesterday, but I unfortunately didn't have the mic pickup set right. So we'll do it again today with volume. We're going to expose the total fraudulent nature of the IRS levy process. Every single levy issued today in the private sector is done fraudulently in an attempt to deceive the custodian, the employer, the bank, or the brokerage house, an attempt to deceive the custodian into committing the crime of unlawful conversion for the Internal Revenue Service, who doesn't have the authority to take the property themselves, which is a requirement within the levy process. And then the courts, of course, excuse the custodians for violating the law, violating the property rights of the employee or the client, and just doing what the IRS tells them to do, even though it can't be supported in the law. And to understand what's going on with the levy and how it's supposed to work properly and what's in the statutes, it's necessary first to understand the history out of which this all evolved. And that takes us back to the Prohibition era of the 1920s and early 30s, or that era where you had alcohol was illegal and Canada didn't care and the gangsters didn't care. They're bringing it in by the boatload across the St. Lawrence and Chicago and New York, all along that river waterway there. So what you'd have are the revenue agents canvassing the warehouse district down by the docks at 2 a.m. in the morning, and lo and behold, they come across a warehouse all lit up, a boat at the dock unloading barrels, men moving the barrels from the boat into the warehouse, loading them onto trucks, and trucks rolling out the warehouse door and into the streets of the city in America to deliver and distribute the bootleg alcohol. But what do the revenue agents do? Do they say, aha, we got them. We'll go see a judge at 9 o'clock in the morning and come back and arrest everybody? And what happens if they do that? They get the warrant at 9, they're back at 10 o'clock, and what do they find? It's a textile mill. Nobody there has any idea what they're talking about. There's no alcohol, there's no barrels, there's no boat, there's no people. This is a textile mill all day long. It's a textile mill. That's what we do. There's no crime here. So they know they can't wait because it's a double operation, right? The daytime operations are just smoke screening the nighttime use of the warehouse. So they don't wait. 2 a.m. in the morning, having witnessed this crime in progress, they move in. They arrest everybody at the warehouse. They arrest everybody on the boat if it doesn't drive off. They arrest and they seize all of the contraband material. They seize the boat. They seize the trucks. They seize all the materials involved in the illegal operation. And then what they do is they write up a notice of seizure listing all the things that they've taken, and they deliver to the owner of the warehouse a notice of intent to levy. And the notice of the intent to levy basically says, paraphrasing, hey, we raided your warehouse, found all this illegal activity going on, got all this alcohol, we seized these books and records that were there accounting for the alcohol coming off of the boat and being put onto the trucks to be distributed to the various parts of the state, city, country. And we've added it all up, and here's the tax, interest, and penalties that are accrued and incurred as a result of the illegal activity that we caught and have documented. And this is our notice of intent to levy. And what that means is you have 30 days to pay the bill or to formally protest it, or we're going to start liquidating at auction all of the assets that we're holding, that were seized, that we have in our possession. And we intend to make levy on those assets, to sell them, to raise money, to pay the tax, interest, and penalties. And if there's anything left over, which there never is, we'll give it to you as the warehouse owner. Now, the warehouse owner is, not involved in the illegal activity. He's just a front for the mafia people who are using his building at night. If he doesn't let them, they kill him. So he just stays away from it and lets them do it, because he can't stop them. And the police are crooked. They're not going to move in and stop it either. It's up to the federal government. So, as I said, They see the activity, they move in, they make the arrest, they seize the property, and then they make levy on the seized property. The key here is that the levy powers and the levy authority only apply to property that is already in the hands of the federal government. That's the key, and it's also the key to understanding the statute that we're going to look at next, because we're going to go through the statutes to see what's there so that we can see where the process goes fraudulent and how to defeat it, as victims are targets of an IRS levy and a third-party custodian who's completely oblivious to the law and the limits of his authority. So the key is understanding that the levy authority and powers only apply to property that is already in the possession of the federal government because it's been seized. And we're going to look at that right now. So let's go over to the code section. And we're looking at 6331, levy and distraint authority of secretary. Now I'm going to need to read these statutes to you. It's a little dry, but let's go through it. A, authority of secretary. If any person liable to pay, okay, here's the first thing you should notice is that you need to be a person liable to pay. You're not made liable by the statutes. This doesn't appear to apply to you. If any person liable to pay any tax neglects or refuses to pay the same within 10 days after notice and demand, it shall be lawful for the secretary to collect such tax and such further sum as shall be sufficient to cover the expenses of the levy by levy upon all property and rights to property, except such property as is exempt under section 6334, belonging to such person or on which there is a lien provided in this chapter for the payment of such tax. So there needs to be a lien to secure the claim is the first thing that's going on. Once they total up the amount that they owe, they have to send you a notice and demand for it. If you don't pay, they file the lien to secure the claim, and then they can make levy on the property that's in their possession. Now, the next sentence is critical because it's the key to understanding why so many people in America are confused about this statute. It's because they don't know the history of the evolution of the levy power relating to prohibition and seizures. But right here, next sentence. Levy may be made upon the accrued salary or wages of any officer, employee, or elected official of the United States, the District of Columbia, or any agency of or instrumentality of the United States or the District of Columbia by serving a notice of levy on the employer, as defined in section 3401D, of such officer, employee, or elected official. If the secretary makes a finding that the collection of such tax is in jeopardy, notice and demand for immediate payment of such tax may be made by the secretary, and upon failure or refusal to pay such tax, collection thereof by levy shall be lawful without regard to the 10-day period provided in this section. Now, this jeopardy assessment and jeopardy collection, it hardly ever comes into play with regular Americans. This is a situation mostly coming out of ATF, where someone's liable to flee with property that could be sold. So the jeopardy assessment hardly ever comes into play. And you'll note that it says levy may be made upon the accrued salary or wages of any officer. Now, people think that this means that only federal employees are subject to the levy powers. And that's not what it says. What it says is that levy may be made on federal employees by mere notice. Why? Because a federal employee's wages are already in the possession of the federal government. They don't need to be seized beforehand. So levy can be made on the wages and salaries of employees by mere notice because they're already in the possession of the federal government and do not need to be seized to bring the levy powers to bear on them. And here it talks about the term levy is used in this title, includes the power of distraint and seizure by any means. Well, any means that's lawful and authorized is what it means. Except as otherwise provided in subsection E, a levy shall extend only to property possessed and obligations existing at the time thereof. And then they got successive seizures, requirement of notice before levy, which is they have to send you a notice of intent to levy. And if you need help with dealing with any of this, you can get assistance at irszoom.com, where we have the letters to answer the notice of intent, the final notice of intent, and the notice of levy, which they are required to send out. And since 1998, they're required to give you a collection due process hearing under 6330, which is how you stick them with process and make them show fulfillment of the requirements at law, which we're going to look at in a minute. But right now we're looking at 6330A, which is the basic power of levy. It says they have to give you notice, they have to include certain information in the notice, they have to say it has to be economical to make the levy, and there's a provision for continuing levy on wages if the first take doesn't satisfy the amount. So here under 6330A, the authority is given to make a levy on property. It's given to make levy on the employees of the federal government in the District of Columbia by mere notice. But what happens if it's not a levy on a federal employee, but rather is a levy in a private sector employer or at a bank or a broker, a private institution? What happens then? 6502, collection after assessment. Now this is a little bit odd because the last code section, 6331, there's a whole series of code sections there. 6330, the collection due process hearing, 6331, the authority, 6332, 33, 34 is the levy is the seizure authorities. But this code section, 6502, is not over with the other code sections series together, the 6330 series for levies. And I suspect that's why most attorneys don't know about this. It's hidden. Also, 6502A is the statute of limitations on assessments or collections of tax after assessment. It's 10 years. So 10 years after assessment of the tax, they can collect it. 6502A is the statute of limitations on collections after assessment, the assessment being the date the return was filed. Okay? So people think that's all there is to it, but wait a minute. B, 62B, date when levy is considered made. Well, why isn't this over with 6331? Look, it refers us right back. The date on which a levy or property or rights of property is made shall be the date on which the notice of seizure provided in section 6335A is given. Oh, well, this is revealing. When it's federal employment, levy can be made by mere notice because the property is already in the possession of the federal government. But when levy is made in the private sector, the date on which the levy is made shall be the date on which the notice of seizure. You mean the date of the levy isn't the date on the notice of levy? Because I'm sure that's what all the custodians think. And it's not correct. Of course, you can go, well, what other date would be the date of legal effect for a document besides the date on the face of the document itself? Well, the other date that it could possibly be is whatever date the law specifies. And if the law specifies a date, and it's not the date on the face of the document, then the date of the face of the document is nothing other than a print date. It's not a date of legal effect or force of law. That date comes from the notice of seizure required under 6335A. And this code section is hidden so that private sector employers won't know a notice of seizure is required for the employer to know when to perform. And without a notice of seizure, which is never issued. Notice of seizures are never issued in the private sector. It's an unlawful conversion by deception. They're deceiving the custodians, the employers, the banks, and the brokerage houses into stealing the money of the American people without legal authority because there's no date of legal effect for the levy to begin operating against the property of the client or the employee unless there's a notice of seizure. Let's look at that. 6335, sale, notice of seizure. As soon as practicable after seizure of property, remember the warehouse, Kennedy District, 2 a.m., see the crime, seize the stuff, and give a notice of seizure. Notice in writing shall be given by the secretary to the owner or the property, or shall be left at his usual place or abode of business. So there's a notice of seizure that's required to give the employer the legal authority to act on a notice of levy from the IRS. So let's look at this a little bit more. 26, this is chapter 75 of subtitle F, administrative procedure, and we're looking here at provisions common to forfeiture, 7321. Let's look at 70. We're going to come back and look at property subject to forfeiture in just a minute. Part 1, these code sections, 7301 through 4. But let's look at 7321. 7321, authority to seize property subject to forfeiture. Oh, you can seize property subject to forfeiture. Any property subject to forfeiture to the United States under any provision of this title may be seized by the Secretary or her delegates. Well, let's go look at property subject to forfeiture. 7301, property subject to tax. 7302, property used in violation of internal revenue laws. 7303, other property subject to forfeiture. 7304, let's look at them. Taxable law, 7301, property subject to tax. This is property that can be seized. Taxable articles, raw materials, equipment, packages, conveyances. Do you see salaries or wages in this list of property that can be seized? It ain't here. Well, let's keep going. Next statute. Property used in violation of internal revenue laws shall be unlawful to have or possess any property intended for using in violating. Well, that wouldn't include your salaries or wages. They're not intended to violate revenue laws. No, salaries and wages aren't listed here as being property subject to forfeiture and thereby subject to seizure. Let's check the next code. Other property subject to forfeiture, counterfeit stamps. Remember the alcohol, tobacco, and firearms activity that this all stems out of originally? And they're paid by stamp taxes. So if you're making up your own stamps to make it look like you're paying tax and putting them on the bottles and sending it out when it's not legitimate, those stamps can be seized. False stamping of packages, fraudulent bonds, permits, and entries. Where's salaries and wages? It ain't there. One more. Penalty for fraudulently claiming a drawback. Whenever any person fraudulently claims or seeks to obtain an allowance of drawback on goods, wares, and merchandise on which no internal tax shall have been paid, or fraudulently claims any greater allowance of drawback than the tax actually paid, he shall forfeit triple the amount. Are salaries and wages subject here? So what we see is that all the property subject to forfeiture, which can be seized, doesn't include salaries and wages. Is there more? 7608, authority of internal revenue enforcement officers. Maybe we can find out why revenue agents and officers of the Internal Revenue Service won't send a notice of seizure with the notice of levy, which is required by law to give a date of legal effect to the levy. So here we have A, enforcement of subtitle E and other laws pertaining to liquor, tobacco, and firearms. Now, this is the general authority of Internal Revenue Enforcement officers. Any investigator, agent, or other Internal Revenue officer by whatever term designated, virtually everyone in the Internal Revenue Service, right down to the janitors, possibly, whom the Secretary charges with the duty of enforcing any of the criminal, seizure, or forfeiture provisions of subtitle E. That's alcohol, tobacco, and firearms. Indirect taxation under Article 1, Section 8. Taxation by excise. Commodities, licenses, and corporations. Subtitle E, ATF. Or of any other law of the United States pertaining to the commodities subject to tax. Alcohol, tobacco, firearms, petroleum fuels. Under such subtitle E, ATF, not subtitle A, income tax, not subtitle C, employment tax, not subtitle B, estate and gift tax, not subtitle D, miscellaneous excise taxes, but only subtitle E, alcohol, tobacco, and firearms. Commodities, taxation by excise. Any other law of the United States pertaining to the commodities subject to tax under such subtitle for the enforcement of which the Secretary is responsible. So first of all, notice the general authority of the agents is limited to ATF. There's no authority under Subtitle A. But let's keep going. What can they do? They may, 1, carry firearms. 2, execute and serve search warrants and arrest warrants and serve subpoenas and summonses issued under authority of the United States. In respect to the performance of such duty, make arrests without warrant for any offense against the United States committed in his presence. Remember canvassing the warehouse at 2 a.m., witnessing a crime? Here it is. Or for any felony cognizable under the laws of the United States, if he has reasonable grounds to believe that the person to be arrested has committed or is committing such felony. And 4, here's the key, in respect to the performance of such duty, make seizures of property subject to forfeiture. You mean they're allowed to make seizures of only property subject to forfeiture? And as we saw in the property subject to forfeiture, it didn't include salaries and wages, only all these items used for taxation, for indirect excise, ATF taxation, stamps, assets, taxable articles, raw materials, equipment, packages, conveyances, remember? And property used in violation of internal laws, and other property subject to forfeiture, counterfeit stamps, false stamping. But who knew that the only thing they're allowed to seize is those list of items that are property subject to forfeiture? They can't seize salaries and wages or bank accounts or brokerage accounts. They're not part of the seizure authority of the revenue officer. The whole thing is a fraud. If he were to ever fill out a notice of seizure to send it to a private sector employer, banker, that would be evidence of a crime. He's exceeding the authority of Subtitle A. And there is no statute that gives the revenue agents or officers, by whatever term designated, any further power than what's delegated here. Everything else, the assessment, the enforcement, it's all delegated within the Subtitle E authority, not outside of it. They're limited to ATF, Subtitle E, here it is. They can only make seizures of property subject to forfeiture. Every single levy is an unlawful conversion where the third-party custodian has been deceived into committing the crime of unlawful conversion and seizing the property for the IRS because they don't have the authority to do it. And that means they're violating the limits of their authority. They can be sued in state court for unlawful conversion, and they have no federal defense. The whole thing is a fraud. But you can stop it cold. But first, before we get to how you stop it, let's take a look at the next code section. Subsection A gives authority to the internal revenue agents and officers to enforce ATF taxation, and that's all. Subtitle E. Seizures for Subtitle E, not salaries or wages, not bank accounts, not brokerage. None of that can be seized. There's no authority for it, and that's why there's never any notice of seizure, and that's why there's no date of legal effect on the notice of levy. And all the employer, the custodian, has to do is write a letter to the IRS going, "We've received your notice of a levy. Please provide the copy of the notice of seizure required under 6502B that will tell us when to begin making levy on our client or employee's wages or property." That's it. We got your levy. We'll do it as soon as you tell us when to begin through the notice of seizure. And your employer will never hear from the IRS. They won't provide a notice of seizure. And you're standing on the statutory provision to need one to know when to begin. Because they can do it by notice to a federal employee because no seizure is needed because the property is in the possession of the government. So levy by notice is legit. But in the private sector, at the banks, at the brokerage houses, any private sector employer, you have to do a seizure, and you can't. You don't have the authority to go after wages and salaries. It's a fraud. It's an enslavement system, not a tax revenue system. Let's look at B. This is critical. Any criminal investigator of the Intelligence Division of the Internal Revenue Service whom the Secretary charges with the duty of enforcing any of the criminal provisions of the Internal Revenue laws, any other criminal provisions of law relating to internal revenue for the enforcement of which the Secretary is responsible, or any other law for which the Secretary has delegated investigatory authority to the Internal Revenue Service, Isn't the performance of his duties authorized to perform the functions described in paragraph 2? We're going to look at that, but first let's look at this. Criminal investigator. He has to be investigating a crime. And it's not just criminal provisions and other criminal provisions relating to internal revenue. It's any other law. This is the authority for civil investigations of subtitle A. Here it is. It's only the criminal investigator of the intelligence division who's allowed to do civil investigations. That means you have to have lied on the tax return. But intelligence is the kickoff. In America, we don't spy on the American people. Anywhere you see intelligence division, you know that's a foreign application of authority. Why? Because it was a tariff act. It's collected from non-resident aliens and foreign corporations. It was never a tax on American citizens. It was always foreign. And the territories, the possessions under Canadian tax treaty and other tax treaties, and paid by non-resident aliens or collected from non-resident aliens and foreign corporations. There's no collection of the tax from citizens until the victory tax in World War II. So the criminal investigator of the intelligence division does the civil enforcement for subtitle A. The secretary has delegated investigatory authority to the Internal Revenue Service, but not to the agents and officers. They only do ATF. Down here, everything else, subtitle A, subtitle B, subtitle C, subtitle D, it's all criminal investigator, the intelligence division, it's all foreign, and it all takes a crime. And not filing a return is not a crime because there's no requirement to file. That's another element of the fraud. So let's again look at the authority and the powers of the criminal investigator in enforcing all the other laws. They're authorized under this subsection to execute and serve search warrants and arrest warrants and serve subpoenas and summonses, just like ATF, the agents under ATF and subtitle E. They're authorized to make arrests without warrant, just like the agents under subtitle E. And they're authorized to make seizures of property subject to forfeiture. Again, the limiting term. And we've seen property subject to forfeiture is defined in law. Any property subject to forfeiture. And here's the code subject to forfeiture. 7301, 7302, 73. The property subject to forfeiture. See it up here? This is the property they can seize. They can't go outside of it. They can't go outside of it even under the 7608B requirement. Again, they're limited to make seizures of property subject to forfeiture. Well, there's no authority to go after salaries and wages. It's all limited by this term, property subject to order. There's never any notice of seizure delivered in the private sector to give a date of legal effect and force of law behind the notice of levy. It's all unlawful and wrongful conversion by deceit and deception. So what do? When you get the notice, I don't have 6330 there. That must be the previous section, 60. Here we go. So when you receive a notice, or when your employer receives a notice of intent to levy, or a final notice of intent to levy, and actually it's only applicable to the final notice of intent to levy or the actual notice of levy, but I like to tell clients, look, it's a notice, it's an initial notice of intent to levy. You should ask for the collection due process hearing right away. Because technically, even though it's early and they may deny it, you're letting the agent know you know about this process, and he isn't going to get to just take your money. He's going to have to fight, and he might just drop it because he can't provide the notice of seizure. And they know that's what's coming. The collection due process hearing gives you an opportunity in front of an impartial IRS person. And you have 30 days to make the request from the final notice of intent or the notice of levy. If you do, the operation of the levy is stayed. Obviously, it's difficult to get a third-party custodian to stay a notice of levy when they're acting on it almost right away. So it's important that you request the CDP hearing on the final notice of intent to levy. so that they never issue a levy for custodians to act on before anything can be done legally to stop or impair them. Because if they act without notice, they're safe. But once you give them notice of their deficiencies at law, because ignorance of the law is no excuse. The fact that the attorneys don't know about 6502 and the requirement to provide a notice of seizure is no excuse at all. It's no legal defense. In fact, it makes them guilty. Because that's your argument? You didn't know? Ignorance of the law is no excuse. You were given notice, it's right there, and I told you about it when I gave you the copy of my request for the CDP hearing on the initial 30-day notice. So what does it say? It says no levy may be made unless the secretary is notified of the right to a hearing. This all comes out of the testimony that was made on Capitol Hill in 1997 or 1998 when they passed the IRS Reform and Restructuring Bill, because basically Congress had a whole stream of people coming before them telling congressmen that their property and their homes had been wrongfully and unlawfully seized on an error, and they were never given any chance to defend their property or explain the error. They just bang took it. And under the Constitution, you're not allowed to just take property without legal process. Due process at law requires some legal process be provided, and there was none inside the IRS levy seizures operation. So they passed this new law, 6330. Before they can make levy, they have to notify you of their intent to do so, which was always in place. But now, in response to that notification of intent, you can demand a CDP hearing. And when you demand the CDP hearing, enforcement of the levy is stayed immediately. So the employer, the bank, the broker can't act on a notice that they've gotten once you tell them you're requesting this hearing. They have to wait for a determination to come out of the hearing before they can act on it. So at the hearing, what do? Well, at the hearing, they're required to matters considered at the hearing. C. In the case of any hearing conducted under this section, the appeals officer shall, at the hearing, obtain verification from the secretary that the requirements of any applicable law or administrative procedure have been met. Okay, produce the notice of seizure required under section 6502 to give a date or legal effect to the levy. That law, 6502, requires a notice of seizure. This law, 6330, my right to a collection due process hearing, says the appeals officer has to verify in writing that all of the laws have been complied with, and they haven't. There's no notice of seizure. So you can't uphold the levy because there's no date of legal effect on it. Even 6 months later, if it takes them that long to get to the CDP hearing after you request it and everything is stayed. Where's the notice of seizure? There isn't one. Therefore, there is no levy that can be sustained because there is no date on which it may legally begin. Because the date of legal effect is not the date on the notice of seizure. It's the date on the notice of seizure, not the date on the notice of levy. It's the date on the notice of seizure. And they're not authorized to make levy on anything but property subject to forfeiture. They can seize property subject to forfeiture. So they'll never write a notice of seizure because under 7608A, that's evidence of their exceeding the authority given to them as an agent and usurping the authority reserved for use only by criminal investigators of the Intelligence Division. Since there's no crime, it's just an investigation of civil law for money, tax. That means it's only subtitle A. This is the only enforcement authority that exists. There's no other statute anywhere in the code that gives them more authority than this subtitle E ATF. There's no seizure authority. They can only make seizures of property subject to forfeiture, and the entire levy event is, again, as I said, an exercise in unlawful conversion by deceiving the third-party custodians into committing the crime of wrongful and unlawful conversion without legal authority to act against the property of the employee who's been targeted. The whole thing is a fraud. It's a complete and total crime. It's racketeering. The agents know it. The judges know it. The courts know it. I'm not sure Congress knows it. I'm pretty sure Joe Biden doesn't know anything at all. But this is the law. This is the truth. Since the collection due process hearings in 98 require them, it's important that you answer the final notice of intent that forestalls the levy. It puts in place a process where they cannot produce the notice. The only thing you do is you go into the hearing going, produce the notice of seizure required under 6502B to give a date of legal effect to the levy. Show me that that law has been complied with as you're required to do under 6330C. Show it to me. Show it to me. You can't show it to me. You gotta knock down the lien. It can't be sustained. The determination has to be that the levy cannot be enforced. No one has to turn over any property. They don't want to render that because it's been a cheat from the beginning. And they got half the country arguing 6331 means levy only applies to federal employees because they're the only ones subject to the tax. Well, we've been through that. Show me where federal employees are made subject to the tax. They're not liable for it. It's not imposed on the wages. The Social Security tax is imposed. The FUTA tax is imposed, but income tax, there's no tax imposed. Federal employees are allowing that to be collected under a wrongful and erroneous presumption, just like the rest of America is. Everyone should be claiming exempt. You have no liability. You didn't collect any tax from a non-resident alien, and 1461 and 1463 are the only statutes in Subtitle A that lay liability for the payment of the tax. It's indirect. It's collected at the source. It's paid by the collector, the same way a store pays the sales tax. Neither collector pays tax out of their own pocket. They only turn over what they've collected from other people. That keeps it indirect. And there's no confrontation in the matter. You go into the store, you know the tax is going to be collected. You either pay it or you don't get the goods. And illegal aliens, non-resident aliens, and foreign corporations are supposed to know the law too. They know that when they get paid, there's supposed to be a deduction. And if they don't know, who cares? Ignorance of the law is no excuse. You're protected. You're required as the withholding agent. You withhold it and send it in. They can't do a damn thing. Because you're acting under authority at law. And as long as you don't keep the money, they can't do anything about it. You're specifically indemnified as a collector under all the statutes. And if you look at all the statutes that lay liability for tax, there aren't any in Subtitle A. There aren't any in Subtitle C, other than to make the employer liable for paying the taxes he's withheld and collected from his employees. So it's the Social Security, the FUTA, and the income tax. But there's no requirement to collect the income tax. That's done because the employee asked for it. They gave them a permission slip, an allowance certificate, an employee's withholding allowance certificate, a W-4 saying single and zero, take 30%, I'm stupid. Married and 4, take 10%. I'm stupid. I'm scared. I live in fear. I serve the beast so he won't attack me and my flesh. Yeah, it's a little oppressive and crushing to the spirit, but hey, the body is, isn't that more important than the spirit? Well, that's what the IRS wants you to think. So the whole thing's a fraud. And again, if you get a notice of levy, a notice of intent to levy, or a final notice of intent to levy, you can go right over to irszoom.com, buy the collection due process hearing letter. It's just $50. You can buy it for any of the 3 notices, the notice of intent, the final notice of intent, or the notice to levy. It raises the arguments, it demands the hearing, and all you do is ask them to produce notice of seizure under 6502B. They can't do it. And if they lie and try to uphold it, well, then you have to take up the appeal into the tax court. They violated the law. He violated the 6330 requirement to show that law had been complied with. They didn't do that. They go into the appeals court if need be. They violated the law. It's the government. The agent exceeded the authority under subtitle under 7608 and subtitle E collection authority. And the officer conducting the hearing didn't verify that the laws were complied with. They specifically refused to address 6502B, which is the date of legal effect for the levy. How can you ignore that statute and go, I sustain it, even though there's never been any legal date? It's criminal fraud. Oh, we're just going to use the date on the notice of levy. What about the law that says that's not what you do? Oh, we don't use that law. I'm sorry, excuse me? What? You mean we get to pick and choose the laws that we use? Why didn't you tell us? I got a whole bunch of laws that I'm not going to use. If that's the game we're going to play. And that is the game the judges are playing. They betrayed America. They've thrown you to the wolves to die in the wilderness, to institute and sustain this peonage plantation operation, where your job becomes the little plot of land, but the wages and the fruits of labor from working the plot of land aren't yours to keep. They actually belong to other people. You're just a slave to the extent that we demand. 10, 20, 30, 50, depends how well you're doing. It's the extent of enslavement we impose. Unless you're doing really, really well, and then we let you off the hook completely. Don't we? Because they don't work as employees. They work off of capital gains or borrowing against assets, which create deductions and no income. Or deductions for the interest on the loan. So the whole system is a fraud. And I put information out on these videos on how to correct it. And this video exposes how to stop the levy. And again, if you need help, it's just $50 at irszoom.com. And if you want to read more about this, I've got more information and documents that lay it all out, explaining the Prohibition era from the beginning to the end, addressing all the aspects, including what information they're required to give you, right? Authority of secretary, seizure and sale, requirement of notice before levy, 30-day requirement. This is the final notice of intent, 30 days, the information to be included relating to the sale, the seizing, the administrative appeals, the alternatives. None of that's sent out the levy. None of this information is included. So it's all fraudulent. And down here, continuing levy on salary and wages. Well, where were they ever authorized to make a seizure of salaries and wages? How would you continue it? Oh, I see. This is only federal employees. This continuing levy only applies to federal employees because their property can be made levy by mere notice, but everybody else requires an authorized seizure. And the IRS says, well, if we use the law, we can't enforce the tax. Yeah, it's because they're lying. There is no tax. None of the money goes in the Treasury. It goes to the Federal Reserve Bank. The master's controlling your government. This isn't a tax system that funds the operation of the government. It's a peonage system that puts the American people into a system of involuntary servitude, servicing endlessly the $35 trillion of debt owed by Congress to their rulers. The private corporation, the Federal Reserve Bank, the recipient of all your so-called tax dollars in violation of law. Section 7809 says every single penny collected for tax has to be deposited in the Treasury on a regular basis. Not one dime goes in. You want to see that? Here it is. Deposit a collection. Except as provided, the gross amount of all taxes and revenues received under the collections, whatever nature received or collected by authority, shall be paid daily into the Treasury. Daily. Now, regulations modify that cycle to weekly, bi-weekly, monthly, or quarterly, and most employers send their tax in quarterly. But look, a certificate of such payment stating the name of the depositor and the specific account on which the deposit would be. That would be your name and social security number and the amount withheld from your pay. But how come on January 10th, after they've sent everything in at the end of the year, you don't have credit for a single dime of tax paid at the Treasury? None of the money taken from your pay all year long even went into the Treasury. Otherwise, there would be a credit for tax paid under your name and social security number, and you wouldn't have to file a return because the tax was already paid. According to the law, it should have been paid. Why wasn't it? It wasn't paid because it wasn't taxed, and they don't have to put monies voluntarily given over to them into the treasury if they're not taxed. They can use them for whatever means they want. And what they're using them for is to collateralize the 35 trillion in debt. Here's your collateral debt service from our peon population. Keep lending us money. Keep lending us money. Because Joe wants to spend another 7.2 trillion next year. It's a peonage system of slave labor, people. It's not taxation. You want your freedom back? This is where it starts. Stop the theft of the money from your pocket before it ever gets there. This is how you stop it. Once the money isn't flowing to the Federal Reserve Bank every week, other week, or month, once the money isn't flowing, they'll stop lending to Congress because the debt isn't collateralized. And as long as you allow your labor to be the mechanism that collateralizes the debt, you will be enslaved to that operation. You will have no freedom, you will have no law, you will have no economic power, you will have no political power. You will be stripped down to the level of the galley slave and worked to death, ultimately. So, I'm sorry, but that's where we're at. That is where we're at. Every single levy in the country is a complete and total fraud. It's a deception on the third-party custodian to get them to commit the crime of unlawful conversion for the Internal Revenue Service, who can't make the lawful seizure to effect the levy and give it force of law on a valid date. And of course, we began by talking about, or mentioning at least, the fact that before they can levy for the tax, they have to secure the claim with a lien. And that brings us to the final point in this video today, is that every single lien in the country is a forged document. If you look at the lien, any lien, go ahead, pick one out if you got one. Go down to the county courthouse and ask them where the federal liens are filed. Pick any one out of the book you want. You look down at the bottom. At the bottom, or down near or on the signature line, there will be a script signature of a name on a line. And then underneath the line, it says for, and then there's a printed name of another agent. So there are two different names, a script signature of one agent and a printed name of another. And the script signature is the signature that actually makes the lien legal, because it's a property conversion instrument being filed in the land records of the state. Without being signed, formally signed, it's not a legal instrument with force of law. It's just a naked claim without standing, because there's no party behind the claim. You have to have a signature on the lien. But the problem is, the script signature on the bottom of the lien is the name of a person you've never heard from. You've never received correspondence from them. You've never had any dealings business-wise at all with them. But the printed name underneath the script signature, that's the name of the local agent who's been dealing with you for ever how long you've been dealing with them. So the question is, how did a script signature of somebody not involved in the case get on the bottom of a lien when they have no involvement in the case of the records? They have no knowledge of what's going on. And I'll tell you what's going on. The script signature is almost always the name of an IRS agent from over 500 miles away, generally in another state, who the IRS claims it will be too burdensome to bring from that other state to testify in any court or legal proceeding. So the local agent should be allowed to do it. But the local agent isn't the one who lodged the claim. The script signature is the one who lodged the claim. The local agent is the one committing the fraud because he forged the name of the script signature. The person who owns the script signature doesn't know their name is being used on the lien. They have no involvement in the case. They did not give permission for their name to be used by this other person in this instance on these records in your case. He's forged the name of another person. He's forged the name of the lien to make it fileable in the state court records. It's criminal racketeering. And the IRS comes into court and says, the regulations say we're allowed to use digital signature images. Yeah, you're allowed to use digital signature images. Your own signature image. You're not allowed to forge the signature of somebody else, even if it's with a digital image. You need to produce the power of attorney that other person gave you to give you permission to use their name on a lien. But there's no power of attorney. There's no permission. They don't know their name's been used. So you need to compel them to appear before the court, no matter how burdensome the government thinks it is. That individual needs to be brought forward because they won't lie. They don't want to go to prison for 20 years. They will say they don't have a power of attorney. They didn't give a power of attorney. They don't have any records for the case. They don't have any involvement in it. They got no idea at all what's involved, and they don't know how their name got put on the bottom of a lien. It got put there because it was criminally forged. Criminally forged by the revenue officer who didn't have authority to seize property. And there is no Subtitle E activity. 100% crime. Every single lien in the country I've seen for the last 30 years has been a forged document, except for some ATF loans. ATF's liens. Somehow they get done right because, of course, there's real tax there to collect, and they have authority to do that, to make the seizures and to make the claims. Subtitle E. So every single lien in the country is a forged instrument, and you should be able to sue in state court because they filed it in the state land records, and only the state court has jurisdiction over the land records of the state. And this is a forged instrument. In order to have a federal defense, you need to show a power of attorney that you didn't forge the signature, because forgery is a crime in both federal law and state law. So you file a criminal complaint, you file a civil complaint for damages, all the money on the lien plus 10 times over. You file it in state court. The IRS removes it. The DOJ removes it to federal court, but it's forgery in the federal court too. So they can't dismiss for lack of subject matter jurisdiction, because a complaint that's filed in the state court and removed to federal court, if the federal court finds it doesn't have jurisdiction and wants to dismiss it, it's not allowed to. It has to remand it back to the state court out of which it was wrongfully removed. If you remove to a court without jurisdiction, that court can't dismiss it. It has to remand it back. If you'd filed it in the federal court, they could dismiss it. But they can't dismiss it when you start the action in state court for forgery and fraud. But that's what you do. You file your civil complaint in state court for forgery. You make it real simple. They'll remove the case, and then you press the forgery issue in federal court, demanding discovery. Bring forward both agents. Let's depose them. Let's find out if agent printed name had a power of attorney letting them use the script name of agent 2 500 miles away. So you can attack the lien in state court. This is every single lien in the country. Every single lien is done this way. Go ahead, look at it. Check the bottom of the paperwork if you got one, or go to the courthouse and check it out. Script signature, foreprinted name. The foreprinted name is forged the signature of the other individual who doesn't know their name is being used in a land conversion action, property conversion action. The whole thing is a fraud. The whole thing is a crime. The American people should shut it down. I can help you with both, because you get a collection due process hearing for every lien they file as well. And you attack it on this is a forged signature, and that's a crime unless you can produce the power of attorney between the two agent names, giving printed name power of attorney to use script name signature on the lien. Doesn't exist. Doesn't exist. This is a method of operation. It is 100% fraud. It's how they operate to get away with this stuff. Oh, he's too far away. We can't bring him from Pennsylvania or Georgia or Texas or wherever he is. That's the case. That script name has been forged, and that makes it a document legally attackable in state court. And somebody's going to have to address the issue of forgery, because the only way to find out if it was forged or not is to go through the deposition process. Bring both people in and let's do the interview and find out what's going on. And then as soon as you depose, you move for summary judgment. Because like I say, the agent won't lie. What? I don't know. I didn't give him a power of attorney. I didn't sign that. I didn't authorize anything. I don't have any records. He told me to bring all the records I have involved in this case. I don't have any. I'm sorry, I couldn't bring anything. Yeah, that's all right. We know. We just wanted you to say it. Because when you say it, it condemns the other agent as the criminal. So the liens are forged. The levies are unlawful conversion. The collection due process hearing opportunity resulting from the 1998 IRS restructuring and reform law opens the door for all Americans to be able to stop both of these processes. All you have to do is respond. All it costs you is $50. If you can't pay the $50, send me an email. I'll provide the letter for you to use for free. You can pay me at some time in the future. This isn't about money. This is about saving America. I don't really care about the $50. I care about stopping the enslavement of the American people to what is partially a foreign-owned company. The Federal Reserve Bank is owned by both American and European interests. Nobody knows for sure because it's never been audited. Also, it doesn't pay any tax because the whole thing was erected as your ruler, your controller. Not part of any honest money system or financing system, treasury operation. Not one bit. The wealthy bankers of the world in the early 1900s brought back the peonage plantation system, and they finished implementing it as World War II gave them the excuses to do so. Starting with the victory tax, which was the first time in history the American people's labors were touched by federal tax. Income tax didn't do it. From 1913 to 1942, there was no income tax paid by American citizens deriving their earnings, salaries, and wages from fruits of labor derived from the simple exercise of the right to work, because rights aren't taxable. Rights aren't taxable possessions, and the exercise of the right is not a taxable activity after the fact. You can get that from Harper v. Virginia Board of Elections in 1964, where they ruled that the $1.50 poll tax was unconstitutional because you can't tax a right. It erects a hurdle to the exercise of the right. So they had to get rid of registration fees to vote. Can't have a fee, got to be free. And you can't charge a poll tax to be allowed to put your marked ballot into the box to be counted. Even if it's as little as $1.50, rights can't be taxed. You have a right to work. They've been telling this since they issued this case in '64, right to vote, right to work, right? Civil rights, your right to work. It's not a tax system, it's a slave system. Not a tax system, it's a peonage plantation debt service system. Wake up, America. Start fighting back. Send the letter to stop the IRS. Stop thinking it's the end of the world and they're just going to take your property. Stand up and fight back. I'm providing the ammunition. All you got to do is buy the ammo. Okay, that's Thomas Freed on the Thomas Freed channel at YouTube and tax-freedom.com on the web and irszoom.com if you need assistance answering any letter you have received from the IRS. I think we're going to go ahead and call that, and we're out.